Good day, Miss Ko. I'm Livinevaran here and my student ID is 0362665. Now let's delve into Mr. Allen's case. Hi, Mr. Allen. My name is Livinevaran. I'm here to help you and clarify your doubts. Let me run through the summary of your case. You, Mr. Allen, has bought Pineview Cottage from Charles. Pineview Cottage is a freehold property. The sale was officially registered. After moving into, you have discovered two issues. That is Tina's lease. Tina has been living in a room on the second floor for 2 years. She claims to have a lease agreement with Charles allowing her to stay for 5 more years and she wants you, Mr. Allen, to honor it. The second issue is David's option to purchase. David is Charles' brother, claims he has an option to buy the property based on a deal he made with Charles 3 years ago. You found no records of Tina's lease or David's option at the land registry. And Charles is unreachable as he is on his holiday in the Caribbean. Now, let's go for your first question. That is, does the Land Registration Act 2002 offer adequate protection for Mr. Allen, that is you, as a registered proprietor? What kinds of interests might override your title? Firstly, let's go through what is Land Registration Act 2002. That is the short form of LRA 2002. Is a UK law that is modernized how long ownership is recorded and protected. It requires most and to be registered with the land registry, making it easier to check who owns what and reducing disputes. However, not everything is listed in the registry. Some rights called overriding interest can still affect a property even though they are not officially recorded. Now let's see what adequate protection does LRA 2002 offers for a registered proprietor like Mr. Allen. Firstly, indefensibility of title under Section 58, subsection 1. Mr. Allen's registration as the proprietor makes him the legal owner of Pineview Cottage. This means that as a general rule, your title cannot be challenged by unregistered claim. Secondly, priority rule, section 29. Interests that are not registered on the land registry or to do not qualify as overriding interest generally do not affect your ownership. This ensures your title is secure and free from hidden claims. Lastly, clear land records. The LRA 2002 aims to ensure that all significant property rights are recorded in the land registry, reducing the risk of unexpected claims arising after purchase. Let's see the overriding interest that may affect you. Under Schedule 3 of the LRA 2002, the certain unregistered interests are recognized as overriding and can affect Allen's title despite not being recorded. These include leases of less than 7 years under Schedule 3, Para 1. Leases shorter than 7 years do not need to be registered but can still bind the new owner. In our case, Tina's lease falls into category, meaning it may affect Mr. Allen's title if she satisfies other conditions such as actual occupation. What is actual occupation? To explain to you, Mr. Allen, actual occupation is a concept that grants a person rights to a property if they were living in or using it at a particular time. These rights includes an overriding interest that can be enforced against the property's registered owner. The, so the case of Abe National Building Society against Scan 1990 is about Mrs. Scan, a protected tenant, was offered the chance to buy a rented home at a reduced price due to a tenant's status. Unable to afford it, a son purchased the property, took out a mortgage, and promised she could live there rent-free. The property was registered in both their name, and they lived there with Mrs. Kent's second husband. After selling the house, the son bought another property in his name, partly using the proceeds from the first sale. The three lived there until the son moved out, later deciding to sell to financial difficulties. A smaller property was purchased with a mortgage from Abe National. The son defaulted and the bank sought possession. Mrs. Scan claimed an overriding interest, citing a tenant status, the reduced price of the original purchase, and her son's assurance of a permanent home combined with her actual occupation. The court held that the relevant time to determine an actual occupation was the date of completion, not registration. Preliminary steps like moving furniture and fitting carpets were insufficient to establish an actual occupation, especially since Miss Can was on holiday at that time. The next overriding interest is discoverability of occupation can be seen in the case of Strand Securities Limited against Caswell 1965. The court in this case emphasized the importance of physical presence or clear signs of occupation. In our case, Tina's ability to claim an overriding interest depends on whether her occupation was obvious and whether you, Mr. Allen, made reasonable inquiries. The final overriding interest is limitation on overriding interests. In the case of Lloyd's Bank versus Carrick 1996, this case highlights the informal agreement alone may not constitute an overriding interest without actual occupation. David's option to purchase would not qualify as overriding since it's not tied to physical presence. As an answer to your first question, Mr. Allen, the Land Registration Act 2002 provides significant protection for you. As the registered proprietor of Pineview Cottage, it ensures that unregistered interests like David's option to purchase cannot affect your title unless they qualify as overriding interest. Tina's lease might override your title if she can demonstrate actual occupation. But Mr. Allen, you could dispute this based on whether a presence was apparent during the sales process. Now let's delve into the next question. That is, can Tina alleged lease bind Allen as the new owner of Pineview Cottage? Tina's lease might be bind Mr. Allen, as an overriding interest under Schedule 3, Paragraph 1 of the Land Registration Act 2002, if it is a valid short lease of 7 years or less, Tina can claim a lease is for more 5 years, making it a total of 7 years. Short leases do not require registration to being a purchaser, but leases validity depends on whether Charles followed the necessary legal formalities when granting it. If the lease is invalid, a claim would fail under this provision. Alternatively, Tina's lease could bind you, Mr. Allen, under Schedule 3, Paragraph 2, if she was in actual occupation of the property at the time of the sale. So, to support, we can see in the case of Williams and Green's Bank against Boland and Thompson against Foy establishes that physical presence and discoverability of occupations are critical factors. First, let's go into the case of Williams and Green's Bank versus Boland, 1981. The court ruled that person living in a property that is called as actual occupation could have an overriding interest that takes precedence over a new owner or lender's claim. In this case, a wife who had contributed to the purchase of a house but was not on the title was found to have an overriding interest because she was physically living there. The decision emphasized the role of actual occupation in protecting unregistered rights. Next, let's see in the case of Thompson against Foy, 2009. The court clarified that physical presence is essential for actual occupation to qualify as an overriding interest. However, temporary absence does not automatically defeat a claim. The court found that a person must still be living in or using the property at the time of the sale. In this case, Mrs. Thompson, who had moved out of a house owned by a daughter, failed to prove ongoing occupation and her claim was rejected. The case highlighted the importance of demonstrating continued the presence or the intention of written established overthinking and overriding interest. Next, Tina has been living on the second floor for 2 years, which suggests physical presence. However, you could argue her occupation was not apparent or reasonably discoverable during your inspection. If Tina's occupation is proven to meet the criteria for an overriding interest, Mr. Allen, you must respect a lease or negotiate a resolution. Now let's go to your final question, whether David's option to purchase will affect your position as the new owner. Okay, your ownership of Pineview Cottage is not affected by David's claim to an unregistered option to purchase. Under the Land Registration Act 2002, LRA 2000, such an option should have been registered as a notice under Section 32 to bind third parties. Since David's option is unregistered, it cannot override your title. Furthermore, options to purchase do not qualify as overriding interests. under Schedule 3 unless accompanied by actual occupation which is absent in this case. The doctrine of overriding interest under Section 3, Paragraph 2 requires an occupation and discoverability of the interest. David was not in physical occupation of the property when Alan purchased it, and no reasonable enquiries would have been relieved his claim. Consequently, David's option do not satisfy these criteria and cannot bind you, Mr. Allen. The case laws to support this position can be seen in the case of Sparrow versus Glencrown Properties Limited, 1991, confirms that options to purchase are contractual rights recurring recurring registration. Allen, as a bona fide purchaser for value without notice, is protected by equity as highlighted in Leos versus Prosa Development Limited 1982, which only binds purchasers if they expressly or impliedly agree to respect an unregistered interest. There is no evidence Mr. Allen had any knowledge of David's claim or agreed to honor it. In conclusion, David's unregistered option is unenforceable against you, Mr. Allen. The Land Registration Act 2002 prioritizes the registration of interest to protect purchasers like Mr. Allen, who can rely on the transparency of the land registry. David's claim fails due to the lack of registration, absence of actual occupation, and absence of evidence to support enforceability against Allen. That's all, Mr. Allen. I hope that I have answered all your questions and cleared all your doubts. If you need more information, do contact me. Thank you.